We'll now recognize our second panel. Ms. Emily McMahon is the Deputy Assistant Secretary for Tax Policy at the U.S. Department of Treasury. Thank you for being here. Pursuant to all committee rules, all witnesses are sworn in before they testify. If you please rise and raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Let the record reflect the witness did answer the affirmative. To allow time for discussion, you have testified 4 hearings before. There will be a clock in front of you counting down to 5 minutes. We would ask for you to be able to get as close as you can to 5 minutes, but obviously you are the sole witness on this panel. You are here for us to be able to hear from you and to be able to ask you questions. So your entire written statement obviously will be made a part of the permanent record as well. But thank you for your opening statement.
Thank you, Chairman Lankford, Ranking Member Speier, and members of the committee. I appreciate the opportunity to testify regarding the premium tax credit created as part of the Affordable Care Act. The ACA established affordable insurance exchanges, also known as health insurance marketplaces, where consumers can choose a private health insurance plan beginning in 2014. So that this insurance is affordable, Congress also included in the ACA a premium tax credit that it has been estimated will help approximately 20 million Americans to afford private health insurance. These premium tax credits may be worth over $4,000 per covered individual each year on average. On August 17, 2011, the Treasury Department and the IRS issued proposed regulations implementing the premium tax credit under Section 36B of the Internal Revenue Code. Final regulations were issued on May 23, 2012. These regulations provide that the premium tax credit is available to eligible individuals enrolling through all exchanges, whether directly operated by a State government or a federally facilitated exchange operated on behalf of a State. The regulations were developed in accordance with our standard procedure for developing regulations under the Internal Revenue Code. Career IRS staff attorneys and attorneys from Treasury's Office of Tax Policy conducted a rigorous analysis of the statutory provisions, drawing on their extensive collective experience interpreting and implementing the code. Public comments were solicited on the proposed regulations and were carefully considered during the development of the final regulations. Treasury and IRS believe that the final regulations interpret the statutory language in a manner that is appropriate to its context and consistent with the purpose and structure of the statute as a whole, pursuant to long-standing and well-established principles of statutory construction. This interpretation takes into account the fact that Section 36B(f)(3), added by the ACA, requires federally facilitated exchanges to report to the IRS data related to eligibility for the premium tax credit and the receipt of advance payments, a requirement that would be pointless unless the enrolling individuals were eligible for the premium tax credit. The regulations also reflect the fact that where a State chooses not to establish an exchange pursuant to Section 1311 of the ACA, Section 1321C of the ACA provides that the Secretary of Health and Human Services shall establish and operate such exchange within the State. In other words, Congress made the federally facilitated exchange the equivalent of a State exchange in all functional respects, including making qualified individuals eligible for tax credits to purchase insurance through those exchanges. I also note that the relevant legislative history does not indicate that Congress intended to limit the premium tax credit to State exchanges, or more specifically, to exclude the federally facilitated exchange. Finally, the regulations are consistent with the explanation of the ACA released by the nonpartisan Congressional Joint Committee on Taxation and with the assumptions made by the Congressional Budget Office in estimating the effects of the ACA, a point that CBO Director Elmendorf recently confirmed in a December 6, 2012 letter to Chairman Issa. I understand that some members of this committee will have questions about our legal interpretation. While Treasury appreciates the committee's important oversight role, it is important to remember that our conclusions also are subject to ongoing active litigation. In fact, I understand that some of those plaintiffs were on the earlier panel. As such, it is important to recognize that only the Justice Department speaks to the Administration's official legal positions as to the merits of our conclusions. I will do what I can to answer the committee's questions today, subject to the Treasury Department's legitimate confidentiality interests and sensitivities concerning active litigation. As you know, the Affordable Care Act is projected to provide health coverage for nearly 30 million additional Americans. Agencies throughout the administration are implementing the ACA to build on the progress already made toward better and more affordable coverage. We welcome the opportunity to continue our work with this committee to achieve these objectives. Thank you.
Thank you. Ms. McMahon, thank you for being here. And we'll have, obviously, questions about how the rule came together. You were a part of that team that actually helped pull the rule together. Obviously, there are other attorneys and other folks that are involved in that process. What was your role in the proposed rule and then the final rule when it was done?
Mr. Chairman, at the time that both the proposed regulation and the final regulation were issued, I was the Acting Assistant Secretary for Tax Policy, and in that role, it was my responsibility to approve regulations implementing the Internal Revenue Code.
Great. Well, part of the process that we're trying to go through today is not only the final decision of it, obviously, and there'll be a legal conversation on that, but how that was pulled together. You used the term, there was a rigorous analysis of IRS, legal, and folks at Treasury and such to be able to look through it and go through the law. Obviously, it's a long law. It's new in its format in a lot of ways. We have asked Treasury for a tremendous number of documents just in trying to gather how was the decision made between the state exchange issue or whether such exchanges, as you mentioned, also includes where was that conversation. What we have found so far is a half-page memo that included that one piece of justification, the such exchanges. That's around if I'm guessing correctly, around a $600 billion decision that was made to be able to include that in. And so we asked for the background of that. Today we actually received a letter from Treasury saying they've given us 500 pages of documents so far to provide the background on that. We actually went and looked at, we've actually received 386 pages of documents, a little bit of miscount there. 154 pages of that was the draft proposed rule itself. Let me just walk through a little bit of what else we received. So 386 pages that we've received from Treasury and IRS about how this discussion came to be. 154 of that was the draft proposed rule. 70 pages of that were a draft of Cannon Adler's law review article that obviously we had Mr. Adler earlier today. 70 pages of that was his. 5 pages were Professor Jost's response to the law review article, so that was, again, after this was done. 59 pages were law cases found through Westlaw when a senior Treasury official asked Cameron Arlton, the Treasury employee tasked with defending the rule, to find good Chevron cases. 11 pages were letters from House Republicans and Senator Hatch to the IRS raising questions about the rule. 45 pages were from public hearings on the 36B regulation. 8 pages were from the public comments that people made about the rule. 3 pages of emails about setting up a meeting to discuss this issue with Energy and Commerce staff. 8 pages were an article from the Centers of Budget and Policy Priorities on the subject, written again after the final rule. 3 pages were a Wall Street Journal op-ed from Cannon and Adler. 3 pages of the debates at a Senate finance hearing between Senator Baucus and Ensign. So again, our requests for documents were about the conversation when this was being discussed early on. What we received was 369 pages of public material or relevant or material that was obviously after that. 2 pages showed us that 6 months prior to the release of the final rule, Treasury was considering Chevron's applicability to this case. The remaining 15 pages of documents were mostly emails from Treasury staff forwarding or commenting on articles from Cannon and Adler and Professor Jost. What we need to know is, how was the conversation accomplished? What happened in that conversation? Was there active discussion? Were there notes taken from that? What we've asked for were the notes about that. What we've received is everything well after that and things that are not relevant, or most of this is public information we could download from the Internet. Not based on those conversations. How can we determine what that conversation was like leading up to this decision?
Well, a couple of things, Mr. Chairman. First of all, we did provide additional materials for review by your staff.
In camera.
In camera. And those materials included at least two legal memoranda relating to both the proposed and final regulations, the memos that accompanied the clearance packages as the regulations, at the time the regulations were published. I understand, as you mentioned, Treasury sent a letter this morning explaining our concerns with providing additional documentation.
Not just additional, just documentation at all on it, because all this is not relevant actually to the question that we asked. We have a lot of pages, but just not, they're just not relevant to what we asked for. Sorry, go ahead.
Well, Mr. Chairman, I can assure you, we did have extensive discussions of the Federal Exchange question, both before the proposed regulations were issued and between the issuance of the proposed and final regulations. There was an IRS Treasury working group that comprised of career staff, IRS attorneys, and attorneys from Treasury's Office of Tax Policy, who analyzed very carefully a number of issues that were presented in the development of the 36B regulations. This was one of them. We considered the issue carefully before, as I said, the proposed regulations were issued. We received a number of public comments on the proposed regulations, and so the issue was reconsidered before issuance of the final regulations. A lot of the discussion was oral in meetings and personal, in-person discussions. But to the extent that there are additional documents that may relate to our internal deliberations, as I think as our letter of this morning explained, we have concerns about confidentiality and the chilling effect that release of those additional documents might raise or might present if we, on the rulemaking process, if we were to provide them.
So there's not any written evidence. There's oral on that as far as the conversations between those. Can we get a list of those individuals that are involved in that conversation specifically about this issue?
Mr. Chairman, I can't provide you off the top of my head a list of all of those individuals. There were a number of people involved, and people came and went at different times. But I can take that request.
Yeah, that'd be great, because obviously there are a lot of issues I discussed. It's a large law, and there's a lot of things that apply to it. This is the specific issue that we're trying to identify. How was that conversation? What was the diligence that was put to that? You've used words like extensive and diligence. That's terrific. We just want to get a chance to get in the feel of that and what actually happened with that. With that, I'd like to recognize Mr. Cartwright.
Thank you, Mr. Chairman. And thank you for coming today, Ms. McMahon. I have some questions for you. First, Ms. McMahon, the Treasury Department issued a final regulation allowing premium tax credits to be available to all people regardless of the origin of their exchange participation. Am I correct in that?
Yes, that's correct.
All right. And now, under the interpretation of the Affordable Care Act put forward by Professor Adler, residents of states with federally operated exchanges would not qualify for the premium assistance tax credits. Now, Ms. McMahon, has our government ever provided tax credits on a state-by-state basis or denied citizens tax credits based solely on their state of residence?
I am not aware of any code provision that operates in that manner, no.
And now, how about this? Was the Treasury Department ever consulted on a carving out of premium tax credits?
To the best of my knowledge, no.
All right. Now, I want to talk about regulation drafting a bit. The Departments of Treasury and HHS have both conducted stakeholder outreach to solicit comments and guidance on a broad range of the ACA's provisions. Ms. McMahon, Treasury invited comment and questions from the public, from scholars, from business owners, from individuals. Am I correct in that?
Yes, that's correct.
Will you tell us how were these comments and questions utilized in the formation of the ACA regulations?
Well, Congressman, we always take into consideration public comments that we received. In a number of cases with respect to ACA provisions, we actually solicited public comment before the issuance of proposed guidance to make sure that our proposed guidance reflected the public input, stakeholder input. When we issued proposed guidance, including the 36B regulations in particular, we received over 100 comments on various issues related to the regulation, and we had taken all of those into account in accordance with our standard rulemaking procedure.
And you followed the standard rulemaking procedure, did you?
Yes, we did.
So was the process, were the efforts by Treasury to design regulations for the ACA similar to other Treasury regulations?
Yes, Congressman. The process was essentially the same as the process that we always use in developing tax regulations.
Okay. Now, was the Department of the Treasury aware of the argument that premium tax credits should be available only in state-run exchanges? Was this alternative interpretation considered during the rulemaking process?
Yes, Congressman, we became aware of that argument in the course of developing the proposed regulations, and we considered it very carefully at that point. And then, as I said, again, between the publication of the proposed and final regulations.
Okay, good. Now, would you characterize the administration's efforts as transparent and fair in the rulemaking process?
Yes, Congressman, I would. We published our proposed guidance for public comment. We received a number of public comments. We held a public hearing at which a number of people testified, and we took into account all of the comments that we received.
Well, now, if we think about it, the fundamental purpose of the Affordable Care Act is to create an inclusive, accessible market for health insurance that makes affordable care available to all. This law achieves this aim in a variety of ways, including expansion of Medicaid, development of health insurance marketplaces, and providing incentives for participation in the health and a strong, sustainable health care system. Ms. McMahon, do you consider the purpose and intent of—
Yes, we do. And the CARE Act, as we understand it, was to achieve universal health care coverage, affordable health care coverage for citizens in every state.
Well, thank you for that. And again, thanks for coming today, and I yield back.
Mr. Jordan.
Thank you, Mr. Chairman. Ms. McMahon, in the previous questions, you indicated that you knew about this constitutional concern when you were putting together the proposed rule and then the final rule, correct?
Congressman, we were aware of the question regarding Federal exchanges. I wouldn't characterize it as a constitutional question. It was a—
But you knew there was a controversy about how this is going to be interpreted, exchanges established by the State. You knew there was a concern, there was a controversy.
We knew that the issue had been raised the first time.
I guess what I'm getting at is, you were aware of it, but you didn't think it rose to any level where it would require any different type of process to reach a conclusion. You just kept it within the same process that the IRS has when figuring out how we're going to establish rules to implement legislation. Nothing unique done.
Well, we became aware of it by reading an article in a—
Did you do anything different than you would do for anything else is what I'm asking?
No, we followed our standard
your established process. And just refresh me, and quickly if you can, what is that established process? I mean, do you have the final say? Is there a group of people who look at, here's how we think the rule should, the law, here's what we think the law says, here's how we think it should work. The group gives you a recommendation, you give it the thumbs up or thumbs down, and then I assume ultimately it winds up on Doug Schulman's desk and he gives it the final okay. Is that sort of how it works?
Well, the process begins with an IRS Treasury working group of staff attorneys who consider relevant issues arising in connection with the implementation of a particular code provision. They do.
Is that working group a formal number, or is it sort of ad hoc? It can be 5 people one day, it can be 20 people the next. I mean, how does that work?
Well, usually at the beginning of the rulemaking process, a group is identified of people who are subject matter experts, and that group comprises the working group for development of the regulation.
And do you know who those people are? I mean, Mr. Langford was hinting at this. Do you know some names off the top of your head, or are you going to get that to us?
As I said earlier, I can take that request back.
Do you know if that group, or did you personally, you get some of these? We had a letter that was signed by 24 members of Congress, several doctors signed. Dr. Rowe, Dr. Desjardins signed the letter, Dr. Burgess and others. Do you know if that group, or if you personally reviewed that letter citing concerns about this very issue?
Congressman, I'm not sure exactly which letter you're referring to. We did receive a number of
we can make it available
comment letters from members of Congress, which we did consider.
You did take a look at that. Do you know if the proposed rule was, I guess, August 17th, or sometime in August of 2011? The final rule was this May, or excuse me, May of 2012. Is that right?
Yes.
And in this decision-making process, we know that the Director of Implementation for the Affordable Care Act, Sarah Hall Ingram, came on board in December 2010 to help implement the Affordable Care Act. Was Ms. Hall Ingram involved in the process of making a determination about this issue?
Yes, Sarah Hall Ingram was involved in discussions generally about the development of the Section 36.
So there's one of the people who was involved. So you can give us one name. Any other names you can give? So we got Ms. McMahon. We know you were involved. We got Sarah Hall Ingram. Anyone else? Was Doug Shulman directly involved with this as well? Was Steve Miller?
Neither of those individuals was involved in the working group, but
Sarah Hall Ingram was.
She was not involved, to the best of my recollection, in the working group of lawyers that worked on development of the regulation. But in the course of that process, a number of people, both within the IRS and Treasury, who had involvement with ACA implementation, were.
Was she extensively involved in this?
Unfortunately, I don't recall.
Okay. Thank you, Mr. Chairman.
Thank you. Dr. Desjardins.
Thank you. Ms. McMahon, thank you for being here today. Secretary Liu's Chief of Staff, Chris Wiedemann, briefed the committee in November 2012 and stated that a thorough legal analysis was not conducted related to the availability of tax credits in Federal exchanges because it wasn't one of the most significant issues considered in the 36B regulation. Was this also your perspective?
Congressman, I'm not familiar with Mr. Wiedemann's comments. I guess I could say from my own perspective, we did consider this question a serious issue. We analyzed it in a serious manner.
Okay. So you feel that you did do a thorough legal analysis?
Yes.
And can you give me examples of what that was? What was the thorough legal analysis?
Well, members of the IRS and Treasury working group looked very carefully at the provisions of 36B itself, at other relevant provisions of the Affordable Care Act, including Sections 1311 and 1321, which address the establishment of exchanges and, as I said earlier, make clear that the Federal exchange is intended to be the functional equivalent of State exchanges. There are other provisions of the ACA as well that relate to the advance payments of the premium tax credit.
Excuse me. Did anyone raise the issue that IRS's and Treasury's interpretation of the tax credit availability in Federal exchanges would have enormous tax and spending implications?
Congressman, we believe that our interpretation of the statute is consistent with the way that the Affordable Care Act was scored by the Congressional Budget Office and the Joint Tax Committee.
Okay, well, that's not the question I asked, but did the IRS or Treasury's analysis at any point factor or consider whether Congress made tax credits available only in State-based exchanges as an incentive for States to create exchanges?
When we became aware of this question, we also became aware that that was the rationale that was being suggested.
Do you have any evidence that the IRS or Treasury ever considered that Congress made tax credits available in State-based exchanges as an incentive for States to create exchanges?
Congressman, in the course of our rulemaking process, we did look very carefully at all of the legislative history relating to the Affordable Care Act, and we found nothing to suggest that the sort of incentive rationale that you are suggesting.
Is there any evidence to support that you did this? You say you did this, and you say there was a thorough investigation. Is there evidence to support a thorough investigation? I mean, remember we got like a half-page brief. Is there anything to show this? You say this, but we're not seeing it.
Congressman, I would simply refer you to the letter that we sent this morning regarding our concerns with release of additional documentation.
Okay. Did Treasury factor into its analysis that ObamaCare's author created large financial incentives, such as an exchange establishment grants, to cover the cost of States creating exchanges, and that the author failed to create any specific funding for the creation of Federal exchanges?
Congressman, I don't recall whether that point was explicitly considered during our rulemaking process.
Okay. All right. On October 12, 2012, Mark Mazur, Assistant Secretary for Tax Policy, wrote a letter to Chairman Isse on the tax credit rule. Mazur wrote, "Throughout the ACA, Congress refers to the exchanges as exchanges established by a State, and exchanges established under the ACA. There is no discernible pattern that suggests Congress intended the particular language in Section 36B to limit the availability of the tax credit." Did you review this letter?
Yes, I'm familiar with the letter.
Okay. Can you tell us how the IRS and Treasury searched for a pattern for references to exchanges in Obamacare?
Well, Congressman, IRS and Treasury staff attorneys looked through the Affordable Care Act and examined all of the references to exchanges to try to determine whether there was any particular convention that Congress had used in describing State or Federal or exchanges or both, and as the letter indicates, we were not able to find it.
All right. When an agency working on a complicated rule is searching for a pattern in the way Congress referred to certain terms, would you expect them to categorize or organize these results? I assume you would, but I don't mean to put words in your mouth.
Well, Congressman, as I've said, our working group did a very thorough analysis.
Did you categorize or organize the results?
I'm not familiar with.
Okay. Do you know that the IRS and Treasury employees have admitted to committee staff that no one at either IRS or Treasury ever categorized or organized references to exchanges, or exchanges established by a State, and exchanges established under the ACA in any way?
Congressman, I'm not familiar with the comments that you're referring to.
Okay. Do you think it is a problem that no one at IRS or Treasury categorized or organized all the references to exchanges established by the State under Section 1311 in order to determine whether a discernible pattern exists?
Mrs. McMahon, you can answer the question. I think we're running close on time, but you can answer that.
Congressman, the IRS and Treasury working group did a very thorough analysis, and I am satisfied that their work appropriately looked at all of the relevant ACA provisions, and I am satisfied with their conclusion that no discernible pattern existed.
But you can produce no evidence as such.
Congressman, I would simply refer you again to the letter that we sent this morning in which we described our concerns with producing additional documentation.
Thank you, Ms. McMahon.
Thank you. Mr. Cardenas.
Thank you very much, Mr. Chairman. My first question is, when it comes to the issue of availability of premium tax credits, which have been of interest to the majority since last fall, I understand that Treasury has responded to the majority's request by providing documents, briefings, and in-camera review of sensitive documents since last August, when the Chairman made his first request for information. Ms. McMahon, would you recount for the committee the number of requests for information made by the majority on this issue?
Congressman, we have received a number of requests for information, both formal and informal. We have provided hundreds of pages of documents, including legal memoranda, some of which we made available for review in camera. Our staff has also met 3 times for a total of 8 hours with staff of this committee to explain our process in developing these regulations and the legal research and analysis that we conducted.
So when it comes to all of those requests between you and your staff and your team, how could your response be categorized? Is it that you have been responsive to those requests or irresponsive?
Congressman, we have done the best that we can to provide the committee with the information that it needs, including answering many, many questions presented by the staff and providing a number of documents, including memoranda that describe our legal analysis. We are happy to continue working with the committee to provide additional information that you may need, but I believe that to date we have been very responsive.
Thank you. While I still have time, Mr. Chairman, I want to take the opportunity to ask that we enter into the record this letter dated July 31st, the heading of Department of the Treasury, addressed to the Honorable Darrell Issa, Chairman of the Committee on Oversight and Government Reform, and it's signed by Alastair M. Fitzpaine. If we can add that to the record.
Without objection.
Thank you. Thank you very much. In addition to that, I have some more questions. I understand that you and your staff have also participated in a number of briefings with committee staff. How many of these briefings have been held, and what amount of time have these briefings totaled for you and your staff?
Congressman, we participated in 3 separate briefings. I believe the total time that our staff spent was over 8 hours. We've had
in meetings, not including preparation?
No, in actual meetings with committee staff. That's correct.
Isn't it also true that the Treasury has made available to committee staff a viewing of sensitive documents without redactions?
Yes, Congressman, that is correct. Some of the memoranda that we originally provided in physical copies were redacted, and when the committee staff requested to review the redacted material, we made unredacted versions of those memos available in camera for review.
Okay. I appreciate your responsiveness to this committee and to the staff and the efforts you have made to detail your rulemaking process as it relates to health insurance premiums, premium tax credits. Are the kinds of documents that Treasury has made available to the committee staff also potentially of interest to the plaintiffs in the 2 lawsuits in Oklahoma and the D.C. Federal Court?
Congressman, my expectation is that yes, they would be of interest to the plaintiffs in the litigation.
because those documents are of the same issue, correct?
Yes, the documents that we provided, at least in part, relate to this question.
Okay. As my time is running short, one last question. Isn't it true that the plaintiffs in those lawsuits have not yet started the discovery process because there are legal questions about whether or not their lawsuits have standing?
Congressman, the Department of Justice is handling the litigation for the administration, but I believe you're correct. The litigation is at the very early stages.
Yes, basically it was a question, but I just stated a truth and a fact. Thank you very much, Mr. Chairman.
Mr. Woodall.
Thank you, Mr. Chairman. Ms. McMahon, I very much appreciate you being here. I hope one day we'll have a Republican administration, but I hope never to be sitting in the chair where you are sitting. So I'm grateful to you for doing that and your team that came with you. $600, $700 billion questions, pretty heady material. I remember we had a former IRS commissioner sitting in that chair who said he was absolutely satisfied that a very thorough examination had been done. It turned out he never even picked up the phone to call to find out if a thorough examination had been done. I know that's not the case with you today, but you've said that several times. The working group did a very thorough analysis. You've said several times, I'm satisfied. You've said several times, I assure you that we had extensive discussions, and yet we have so very little paperwork to support all of that. I've reviewed the in-camera materials that we've had a chance to see, but can you tell me, because this is so important to my folks back home. They do read statutes that get published as plain language. If it says state exchange, they think it means state exchange. Do you remember when these conversations were beginning? Do you remember this being an important issue that this working group, that this team was trying to sort out because the language of the statute was so plain?
Congressman, I do remember when the issue was first identified, largely because I was the one who first became aware that some individuals were suggesting as a possible interpretation of the relevant provisions that the credit would not be available in a Federal exchange. I read an article.
So the working group was already going on. The analysis had already begun. This thing was already robustly established and producing, and then you heard that this might be an alternative interpretation. Is that kind of the timeline?
Well, this was at the time that we identified this issue, we were also in the early stages of the process, I would say, and were identifying a number of issues that would need to be resolved.
Do you remember any discussion that said, golly, if we don't resolve this in the affirmative, our entire vision of how these subsidies are going to be deployed across the country is going to come unraveled? I mean, again, this is a huge decision. If you decide the other direction, folks in my home state of Georgia aren't going to receive any subsidies whatsoever. So that the import cannot be overstated. Do you remember any discussion that said, if we don't get this right, we are going to sweep out the foundation on which the President's health care plan is established?
Congressman, I would say that we recognized that the interpretation that the credits would not be available on Federal exchanges was inconsistent with our understanding of the purpose.
I'm asking a very different question, and again, I know you have a staff of professionals that you work with, but this is not an ordinary issue. This isn't a 501c4 issue. This isn't a can I claim a homeowner tax credit issue. This is the President's landmark social agenda program going to be held to the statutory standard under which it was passed by Congress and signed by the President. I can't imagine that this discussion was held at IRS headquarters throughout the Treasury Department, and there was not some discussion of, we've got to get this done. Is it your recollection that that was never a topic of conversation? No one ever felt that sense of urgency that we've got to get this right because otherwise the President's social agenda comes unraveled?
Congressman, we analyzed this question.
I understand that, and you've said that several times, but I'm asking a question that no one else has asked, and so I'm expecting the answer to be something different than what you've given to everyone else, and that is, do you recall that topic ever coming up in all of these extensive discussions that you've had, the thorough analysis that you had, all of those conversations that satisfied you that this was done properly? And if the answer is no, that's okay. I just wanted to know.
Congressman, as I've said, we appreciated the fact that the interpretation that you're suggesting would have been very inconsistent.
I don't think you're going to answer my question, Ms. McMahon, and that frustrates me. Could I get the slide up here? Because I've just got 4 sentences that I'd like to put there on the board. This is the analysis that I saw in the pre-proposed regulatory language. 4 sentences up here in this analysis. My friends at CRS, who are not burdened with the actual responsibility of implementing this, produced 10 pages for us of pros and cons, helping us work through what the issues were, what the patterns were, what the legal doctrine was. 4 sentences is what I've gotten from you all, from the very extensive discussion groups, the very thorough analysis. And it says in sentence 4, the phrase established by a state may be interpreted to refer to an exchange established to operate in a state. Can I just ask you, what are the other exchanges? We're going to interpret the phrase established by a state to mean these can do the ones that are established to operate in a state. What are the other exchanges that this phrase doesn't refer to? Established by a state may be interpreted to refer to an exchange established to operate in a state. What are the other exchanges that we're concerned about? We're going to interpret this one to mean these exchanges. What are the other exchanges that it could be interpreted to mean?
Well, Congressman, in addition to the exchanges established by a state, there are obviously federally facilitated exchanges.
The different exchanges, the ones that aren't these, the ones that are the other ones. I mean, because I think that's exactly what my folks back home think, that you're exactly right. There's the ones that are established by a state, and then there are all the other ones that aren't established by a state, which is why we had this language in here. Mr. Chairman, there's no mention of this issue in the proposed reg clearance package, and I just find it unbelievable that as a freshman member on this committee, a first-year member of this committee, I can't see the documentation that was produced for folks that say it was an extensive discussion. It was a very thorough analysis. I get 4 sentences and some in-camera documents for something that is the largest single dollar value issue that this Congress and this nation are going to consider in 2013. I thank the Chairman.
Thank you. With that, I recognize Ranking Member Mr. Spear.
Mr. Chairman, I must say that I am deeply troubled by the attack approach that is taken by virtually every other member of the Republican side of the committee, with the exception of you. You, for the most part, have shown great deference to the witnesses, speak politely to them, ask questions in a manner that they can answer. This is not a courtroom. I think bullying witnesses that come before us is inappropriate as colleagues that sit here in an effort to try and find out information. Now, having said that, I find it particularly interesting that we will dice and splice the language in the law and the regulation here on the Affordable Care Act, but in the IRS code that specifically says that a 501c4 will be exclusively for the social welfare purposes in this country, and then the IRS comes in and by regulation changes exclusively to primarily, we haven't had one iota of an interest in delving into that particular issue. Instead, we have spent months looking at the IRS and trying to find a link between the White House and the IRS with the establishment of 501c4s that were conservative in nature. And then, lo and behold, we find out that they were treating 501c4 applications that were progressive and conservative the same. And they were looking at them. Well, the reason why they were looking at them is because it's really hard to understand where that line is drawn. But the discussion that went on earlier today about how it would be absolutely outrageous for a regulatory entity to obscure a statute, which was what our first panelists were talking about for the most part. It's kind of like doesn't relate when it comes to the IRS. And I think that's just quite entertaining at the very least. Now, Ms. McMahon, I thank you for being here. I want you to know you're not being treated any differently than any other administrative person that comes to this committee and is raked over the coals by my colleagues on the other side of the aisle. And I regret that, and I apologize on their behalf, with the exception of the chairman, who has always shown great discretion. Now, let's go on and discuss this issue. Is it not true that this particular bill, the Affordable Care Act, was debated ad nauseum in the Congress of the United States? Maybe not ad nauseum, but
yes,
deliberatively
it was debated
and extensively.
Yes.
All right. So we had a robust legislative debate on this issue. The Senate Finance Committee alone marked up the bill for more than 3 weeks, producing a transcript of nearly 3,000 pages. The subsequent floor debate lasted more than 1 month. Now, I recognize many of my colleagues weren't here at the time. I was, and it reflected more than 400 pages in the congressional record. If, in fact, the intention was to create a carrot-and-stick relationship with the states, don't we think that at some point in time that would have been raised by someone?
Yes, Congresswoman Spear, we reviewed the transcripts of the floor debates to try to find out if there was any discussion of the carrot-stick approach that you mentioned, and we did not find any discussion of that approach or any evidence that that was the approach that was intended.
And wouldn't it be something that would reflect poorly on members of Congress that we would only want to give the value of affordable health insurance to some people in the country and not all people in the country?
Congresswoman, we believe that the Affordable Care Act was intended to provide affordable health insurance for individuals across the country. We agree with that objective, and we are doing our best to implement the ACA in a manner consistent with that objective.
So, copious documents were reviewed. The references to a premium tax credit that would be offered to exchanges in the state was not ever set forth as one that was going to be a benefit only to those states that offered exchanges. Correct?
That's correct. We did not find any evidence in our review of the legislative history that there was any intent to exclude the Federal exchanges from the scope of the premium tax credit.
We had a request of the chairman of this committee to the Congressional Budget Office, and the CBO wrote back, "To the best of our recollection, the possibility that those subsidies would only be available in states that created their own exchanges did not arise during the discussions CBO staff had with a wide range of congressional staff when the legislation was being considered." Is that consistent with your experience in having researched this issue as well?
Yes, Congresswoman. That is consistent. That letter is consistent with our understanding.
All right. So, based on the transcript from the Senate Finance Committee, the floor debates, and the full congressional record, do you believe that Treasury's interpretation of exchanges was reasonable?
Yes, I believe it was reasonable and indeed the better interpretation of the statute.
Thank you. Mr. Chairman, you've been very generous. I yield back.
Dr. Gosar.
Wow. Presentation of facts. Mr. Ms. McMahon, are you aware that the IRS and Treasury's analysis of relevant legislative history considered the House bill and House floor statements prior to December 24th of 2009? That you actually reviewed prior bills before?
I believe that the prior bills were taken into account.
Yeah. Isn't it true that the House passed the exact same version of Obamacare as the Senate passed? Let me rephrase it again. Isn't it true the House passed the exact same version of Obamacare as the Senate passed? I mean, Scott Brown made that. I think it's an easy answer.
I believe that's correct.
Yeah, it is a yes. Isn't it also true that the House debate prior to the passage of Obamacare in the Senate on December 24, 2009 cannot be considered relevant legislative history? So prior to taking this up, so prior to December 24th, that history prior to that cannot be brought up. It's not relevant. I mean, this is easy.
I'm not sure that we can make. I can make an equivocal statement.
So how long have you been in your post?
I've been in my particular job at the Treasury Department for 4 years, approximately.
Okay. Do you recognize that a search of the House debate prior to December 24, 2009 was inappropriate and could not be considered relevant legislative history?
Congressman, I'm afraid I
The answer is yes. The answer is yes.
Well, Congressman, I'm afraid I don't really understand the question.
Well, you're taking up prior information. You're taking at what was actually debated on the House that had nothing to do with the Senate version. Because what I asked you is the House passed the exact version of the Senate, did it not? It did. So the relevant aspect does not apply. It is not inappropriate to consider that discussion prior to December 24, 2009 in the discussions of what the law means.
Congressman, with all due respect,
see, I'm really having problems here because, see, I'm a dentist, and details are a lot to me. The beauty's in the detail. And I'm having some real problems here that we pick and choose whatever information we want to and the facts that we want to. So let's continue. In the briefings, Treasury and IRS employees told committee staff that the review of the legislative history did not include a review of PPACA's 2 antecedent bills. To the best of your knowledge, is it true that the review of the legislative history did not include a review of PPACA's antecedent bills?
Congressman, I would have to go back and ask that question of the Treasury staff. I can't recall at this point the answer to that question.
This is, I mean, here we're talking about something that I know a little bit about health care, about something so personable to people that we ought to get this right. I'm going to ask you again, are you aware that the antecedent Senate bills condition premium tax credits on State compliance?
Congressman, I'm unfortunately not prepared to discuss the antecedent bills. I'm happy to take the question back and provide you with an answer later.
So do you think the questions I'm asking are relevant? These antecedent bills, are they not relevant?
Mr. Chairman.
I do not yield.
Congressman, I am not suggesting that your question is irrelevant. You are obviously entitled to ask any question that you like, and we will do our best to.
Well, this is very important, don't you think? I mean, in constructing this legislative agenda and looking at this, the beauty is in the details, and this is very, very pertinent information. Very, very pertinent information. Because what I see here is we have this Senate bill, and it came over to the House and they passed it verbatim. No changes, because they couldn't afford the changes. Because, I mean, that's where I want to go to next. It was this letter from the House. At the April briefing you had with committee staff, you were shown a letter that Texas Democrats in the House sent to President Obama, then Speaker Nancy Pelosi, and then Majority Leader Steny Hoyer. During that briefing, you stated that that was the first time you had seen the letter. Is that correct?
That is correct.
Did anyone at IRS and Treasury consider that unusual circumstances of the passage of PPACA, more specifically the election of Scott Brown in January of 2010, meant House Democrats needed to pass a Senate bill that they knew was flawed or not pass a bill at all? You're aware of the numbers in the Senate, right? So it wasn't going to move unless it was exactly the same bill.
I am aware of generally of the process that led up to enactment of the Affordable Care Act. I cannot tell you in detail whether the particular the political aspects of that were considered in the manner that you're suggesting.
Well, I think this is very important, ma'am, and because it is very pertinent to the law, because the Senate bill is very poignant to state-run exchanges. It doesn't talk about Federal exchanges or those states that opt out. It only talks about state exchanges. And that's what's so interesting about this context, is the beauty is in the detail. We're not entitled to pick and choose if it doesn't exist in statute. And that's why this is meaningful, and that's why we want answers to all these questions. So I would expect the answers back. I yield back, Mr.
Thank you. Ms. McMahon, let me ask a separate question. And it deals with the advanced subsidy, the tax credit. Those tax credits are going to be sent out to those who qualify monthly. It doesn't get sent to them, it gets sent to their insurer, correct? Their qualified health plan.
That's right, to the insurance.
So I'm going to give you a hypothetical situation, just trying to process through this. We've got a person that qualifies for it, they sign up, they go through the process, payments start getting sent. 4 months into it, the individual stops paying their portion. The government's still continuing to pay theirs. The individual stops paying their portion. Is there a system in place for the insurer to notify the IRS to let them know, hey, this person stopped paying? And do we know yet how that's going to function? I know it's separated, it's somewhat connected to, I think, where you're at, but do we know yet how that's going to work? That's a recent question that's come up.
Congressman, that is an aspect of the implementation of the Affordable Care Act that I am not personally involved with. The IRS is handling, I believe, those sorts of questions.
Okay. It's an interesting thing that we just processed. I didn't know if you're connecting that group at all and what it may be, but we don't know yet how, if someone stops paying at some point, how everybody's going to be notified or what the consequences for that or how that's going to work. The reference that we've talked to a couple times about the such exchanges piece, Treasury has argued that the such exchange in 1321 refers back to 1311 and really puts them as equivalent. Is that correct?
Yes, that's correct.
In the memo, that seems to be the crux of the argument, to say that they connect the two. In the reconciliation report, though, it lists them separately. It lists a 1311 and a 1321 and keeps them separate. And I think part of the struggle that we have is trying to figure out, the reconciliation language seems to keep the Federal and the State exchanges different. They don't just refer to the, if they're equivalent, why refer to both and keep them separate? So there is some ambiguity in the law, and I know the earlier panel you weren't privy to be able to hear some of the earlier conversation. But there's ongoing conversation about what does the statute say and what does the statute mean, or what's the purpose of it. A couple of times you've referenced that you felt like it was the purpose of the law to be able to provide this coverage. We're struggling with what the text of the law says, and that's part of the challenge of it. You also mentioned you went back through legislative history and couldn't find anything that had the carrot and the stick approach. Did you also find anything through the legislative history that you can recall about suggesting there be tax credits for those that are in Federal exchanges?
In our review of the legislative history, we did not find any specific references to the premium tax credit being available in either State exchanges or Federal exchanges, is my recollection. Our review of the legislative history was consistent with our understanding of the purpose of the Affordable Care Act, which was that the credits would be available in all exchanges, whether State or federally facilitated.
Okay. During the briefings, you mentioned the 3 different briefings and the request for documents. It came up that there are about 50 emails that Treasury considers privileged emails that are related to this topic. Would there be a day at some point we could see those things even in camera to be able to evaluate these 50 emails? Do you know why they would be considered privileged information?
Well, Mr. Chairman, the letter that we sent this morning explains our concerns with the release of additional documents. That being said, I mean, we are still in ongoing discussions with your staff about providing you with any additional information that you may need, and we're happy to continue those conversations.
Okay. I just know that when I've dealt with counsel before and attorneys, they take copious notes, as your staff behind you is currently taking copious notes as well, rightfully so. It's the right thing to do. And that's part of our challenge of this, is that we know that those notes would have occurred because it's important when you deal with issues this large, and obviously a $600 billion plus decision is going to have some sort of note-taking through the conversation, how that actually occurred, and then a track with it. And we'd just like to have the opportunity to be able to know how that functioned in the days ahead. So with that, I'd recognize Ranking Member Mrs. Speer.
Mr. Chairman, I'm going to forego asking any additional questions, but reserve my right depending on how the rest of the question goes.
Mr. Woodall.
Thank you, Mr. Chairman. I think that Ms. Speer is absolutely right, that for everybody who works in the executive branch, you do deserve an apology. You deserve an apology from Democrats who refuse to do good oversight on Democratic administrations and Republicans who refuse to do good oversight on Republican administrations. That issue that Ms. Speer cites is spot on. It's outrageous that the Congress passed a statute that said exclusively, and we've been operating under an IRS regulation that says primarily, and absolutely no one's doing anything about it. For the life of me, I don't understand how we advantage those of you in public service when we pass statutes and then refuse to follow up and make sure those statutes are implemented. I want to ask my question again, because I think you're very proud of your team, and I think you're very proud of the work your team has done. And I'm thinking only one of 2 things are true of all the discussions you've been involved in on this issue. Either folks have talked about how important this is to the President's agenda, and that we need to come down on that side of the issue in order to make that domestic social policy a reality, or those conversations have never occurred at all. It would be shocking to me that folks, we all like to work on a team. I've sat on the same row that your staffers have sat on behind you. We all want to see our ideas succeed, and we want to see the American people served. Do you recall in all of these extensive conversations, all of this aggressive review of this $600 to $700 billion question, do you recall any conversation about how important it was to get to this interpretation, because without this interpretation, the President's chief domestic policy agenda would crumble?
Congressman, I do not recall conversations of the specific type that you describe. We did, as I've said, a very careful and thorough analysis of the statute. We recognized that the interpretation that was being put forward, that the credit would not be available on Federal exchanges, would have been a very different approach than we believe was contemplated by the Affordable Care Act. We appreciated that it would have been a very significant difference. However, we analyzed this question applying longstanding principles of statutory construction.
Well, I appreciated your answer earlier where you said no reasonableness. This wasn't a reasonable interpretation. This was the proper interpretation, right? We don't want folks to try to get to the reasonable interpretation. We want them to get to the proper interpretation. I appreciate your emphasis on that. Let me go back to something that Mr. Cartwright asked earlier, and Ms. Spear may have touched on it as well, talking about how tax code treats people in different states differently. I remember when we passed the sales tax deduction, and up until then, we only gave a deduction for state taxes to those citizens in states that had state income taxes. If you didn't have a state income tax, you didn't benefit from this proposal. In the statute that we're talking about today, we said if you do what we want you to do, you'll get your full Medicaid allotment of dollars. But if you don't do what we want you to do, you're not going to get any Medicaid dollars at all. Quite contrary to that larger purpose of trying to provide care for everyone in America, this statute said explicitly, not only are you not going to get care tomorrow, we're going to take away the dollars that you're using to give care today. And the Supreme Court rightfully said that's an outrageous use of federal power. So it seems like there are lots of examples in our history and in our present of using the tax code to treat some people in some states differently than we do people in other states, and to use the Affordable Care Act as a hammer, not a carrot approach, but the stick. Did you consider those things? Do you agree with my analysis of those two circumstances as they exist today, and did you consider those in the analysis that you performed?
Congressman, I mean, yes, we are aware of the provisions that you describe relating to Medicaid and the state
the stick approach as opposed to the carrot approach.
However, as I've said, in our review of the legislative history, including the floor debates, we found no evidence that there was any discussion of the sort of carrot-stick approach in connection with the premium tax credits.
But it is consistent with past IRS practice to treat folks in some states differently than we treat folks in other states based on statute. Only those with income taxes get to deduct income taxes. Only those folks with state exchanges get to deduct insurance premiums. That's consistent with past practice.
Congressman, you are correct that taxpayers in states that have no income tax are entitled to deduct their sales taxes. That is not an IRS practice. It is a alleged provision of the Internal Revenue Code.
Because the statute chose to treat people in some states differently than it chose to treat people in other states. Again, I thank you very much for being here. Thank you, Mr. Chairman.
I thank the gentleman. Ms. Spear?
I want to thank Ms. McCann for being here. You did yeoman's work under taxing circumstances, and we thank you for your service to our country.
Thank you, Congressman.
I thank the gentlelady. I thought for a second I saw a smile. Warmed the dentist's heart. I'm going to ask a few more questions, and you're holding up well, so you can continue that smile. Prior to the release of the proposed rule in August of 2011, Treasury produced a proposed regulation clearance package, August of 2011. In this clearance package, the issue of whether subsidies would be available in Federal exchanges is not even mentioned. Why not?
Congressman, I don't recall. I did not prepare the memo that you're referring to, and I don't recall why the issue was not included in the memo. However, I do know that the issue was discussed and considered actively before the issuance of the proposed regulations.
Who at Treasury produced this clearance package?
I don't have it in front of me, but it is usually the staff attorney within the Office of Tax Policy who is the principal liaison to the IRS Treasury Working Group that works on the regulations. I think the memo that you were referring to was produced by David Gamage, who was that attorney at the time.
Could we make sure and make sure we have that access, please? That answer, make sure it's specific. I know you gave us the answer, but you were kind of unsure.
Yeah, I can certainly go back.
You were part of a team that briefed committee staff in April on IRS and Treasury's decision to extend tax credits in Federal exchanges. Do you recall Rebecca Ewing or your staff telling committee staff that in the early stages there were no real discussions of whether tax credits would be available in Federal exchanges, and that a conclusion was quickly made that tax credits would be available in all States?
Congressman, to the best of my recollection, what our staff said at that briefing was that originally the working group had assumed that the premium tax credits would be available in both State and federally facilitated exchanges because that was consistent with their understanding of the Affordable Care Act. However, when we identified this interpretive question after reading a press article at that point, there was discussion of that question and analysis performed.
Okay. And as a follow-up, if 1311 and 1321 exchanges are equivalent, as the administration argues, why was it necessary to mention both Sections 1311 and 1321 in the reporting requirement added by reconciliation?
Congressman, I really don't know why there was a difference in the language used in the information reporting provision that you cite and other portions of Section 36B. As I've said, we did look at not only 36B but other provisions of the ACA, and we were not able to find a clear pattern for when references to exchange or exchange established by a State or Federal and State exchanges were used.
I just guess my point is if they were the same, wouldn't mentioning 1311 be sufficient? I mean, I'm also one of those clear path of least resistance, 2 points of reference. If they're all the same, 1311, that's all you'd have to do. So it shows us a moniker that there's some kind of problems here statutorily.
Well, Congressman, there are other relevant provisions of the ACA that refer simply to an exchange, including provisions relating to advance payments of the premium tax credit and determinations of eligibility for the premium tax credit. And the term exchange is defined broadly to include both State and Federal exchanges.
But the Senate bill was about State exchanges, not about Federal exchanges. Now, did anyone at IRS or Treasury consider that Congress referenced both 1311 and 1321 exchanges because they intended those exchanges to be treated differently?
Congressman, our interpretation of Sections 1311 and 1321 was that, in fact, Congress intended them to be functional equivalents, that the Federal exchange would be a functional equivalent of.
So I guess my point, not to interrupt you here, but I have to, is that the Federal bill or the Senate bill talks only about State exchanges for these subsidies. So it's very, I mean, this is a sticking point. See, we have this balance. There's the judicial branch, the executive branch, and the legislative branch. And what we have to start doing is when we write poor legislation, we have to acknowledge we got poor legislation. And we can't have the judicial branch stepping in or the executive branch messing into that. It has to go back and redefine. There are consequences for writing bad language. Do you understand that? We can't go in here with the judicial branch going and intercepting the legislative branch. It doesn't work. And that's where we're in a sticking point right here. Do you understand that? Because it seems like we got a bunch of eggs here, and we're mixing eggs right and left, lemons, oranges, everything in that basket. We looked at details on House legislation prior to December 24, 2009, and yet the House passed the exact same version of the Senate bill. This is where our problem is, and this is kind of the sticking point. One last one. Okay. Prior to your April 2013 briefing with committee staff, did you ever raise a point that the law referenced exchanges established by the Senate under Section 1311 only when Congress was making requests for States for actions
I'm sorry, Congressman, I'm not sure what you're asking. Did I raise this question when?
Did you, in April of 2013, this year in April, did you ever raise a point that the law referenced exchanges established by the State under Section 1311 only when Congress was making requests for States for actions?
Congressman, we considered the language of 1311 and 1321 in conjunction with our development of the proposed regulations, which occurred in 2010 and 2011.
Yeah. Can you do follow-up for any evidence that you may be able to provide along those lines?
Congressman, I can take your request for additional information back, and we will see if we can provide you with additional information.
I would hope so. Before it was ruled unconstitutional by the Supreme Court, the PPACA withdrew all Medicaid funds to States that did not expend Medicaid. Withdrawing all Medicaid funds in non-compliant States also appears inconsistent with the purpose to make health insurance affordable for all Americans who cannot otherwise afford it. Was the decision to withdraw all Medicaid funds consistent with the purpose to expand health insurance?
Congressman, I am not an expert on Medicaid, but I believe that the particular provisions relating to Medicaid and the situation you describe were well known at the time of the enactment of the Affordable Care Act, and the consequences to the States of expanding or not expanding Medicaid were discussed at the time.
So do you see any parallels? Did you personally see any parallels with how we restricted or looked at the restriction of Medicaid funds to States with parallels for exchanges in States?
Congressman,
was that part of an analysis of it?
As I've said, we did not find any evidence in the legislative history that Congress intended in contrast to that, the provisions you describe relating to Medicaid were discussed and debated at the time of the passage of the Affordable Care Act.
So do you recognize that looking at this law, that health insurance under this law, do you recognize that?
Congressman, the purpose of the Affordable Care Act overall
I don't, with that purpose, I want your personal evaluation. There's inadequacies here that are actually going to stymie health insurance for individuals. Do you agree with that?
Congressman, we are concerned, obviously, that States that choose not to expand Medicaid.
Well, even those States that take it, there's a problem here. Do you not see that there's a conflict in the way the application of the law, regardless of how we apply this, that there's going to be an inadequacy about how we actually get insurance to individuals? Isn't there individuals that are going to be hurt by this law in getting health care insurance?
Congress, unfortunately, I am not an expert in Medicaid, and the Medicaid program is not within the jurisdiction of the Treasury Department.
Okay, so let me go to this. Was the withdrawal of Medicaid funding ever discussed by the IRS or Treasury during their analysis?
I'm afraid I don't recall whether that question was specifically discussed.
If we could ask staff to follow up on that. I got two more. Okay. Prior to your April 2013 briefing with committee staff, did anyone at IRS or Treasury bring up that the reconciliation bill explicitly created equivalence between territorial exchanges and exchanges established by the Senate and State?
Congressman, I'm afraid I don't know the answer to that question either off the top of my head.
So will you supply the answer to that, please?
I can take that question.
Yeah. And last but not least, here's a smile time. Okay. Did anyone at IRS or Treasury consider that Congress, as they did with U.S. territories, could have explicitly offered tax credits in Federal exchanges through reconciliation?
Congressman, as I've said, we believe that our interpretation was consistent with the provisions of the statute as a whole as it was finally enacted. I don't know personally whether the working group considered the language of the antecedent bills in their analysis.
Thank you. I'm going to yield back to the Chairman of the full committee.
You're nearly done. This is almost administrative, but I'd like to go through a couple of things with you. You used a term just now. Perhaps you could repeat it. You tried to work consistent with the final enactment of the bill. Could you repeat what you said, or I can have it read back?
I believe what I was trying to say was that in our rulemaking process, we analyzed the Affordable Care Act in its final form in the manner in which it was finally enacted.
Okay. Well, let's take that, because you're a political appointee. Your job is to do the bidding of the President. The people who did the analysis, I assume, are political appointees who did the bidding of the President. The President wanted the Affordable Care Act and clearly wanted it to be as broad as he could, even when States pushed back and said no. Is that a fair statement, at least from this side of the dais?
With all due respect, I do not believe that.
Are you a political appointee?
I am personally a.
Were the other individuals involved in the analysis primarily political appointees?
No. In fact, they were not. The working group of tax lawyers that did most of the work on development of these regulations included career IRS staff attorneys in the Office of Chief Counsel and non-political staff attorneys in Treasury's Office of Tax.
Well, great. And where the hell's the paper on that? Quite frankly, you claim to have sent me 500 pages. We got 386 pages, and 154 of them are the proposed rule itself. Where's the analysis? Congress doesn't agree with you, at least the House of Representatives, that your rule is consistent with the law. We asked for the analysis. You've stonewalled us. Where's the analysis? Or are we going to get into the deliberative process? Are we going to get into how you decide to make a decision that's not supported in the law? You're not going to give us papers that effectively tell where that is. Are you prepared today to say you've given us full discovery when you say you have career lawyers who worked on this? Where are the notes, recommendations, analysis that we asked for?
Mr. Chairman, Al Fitzpaine of the Treasury Department sent a letter to you and others this morning that explains our concerns relating to confidentiality and sensitivities relating to the active ongoing litigation, concerns relating to your request for additional documentation. That being said, his letter did describe the documents that we, additional documents to the ones that you have seen that we discovered in our internal search.
Well, let's go through your search. $600 billion this bill is going to cost, and you tell us there's 50 emails that are responsive to that. Is that really what you're saying? Did you not use email at Treasury?
Mr. Chairman, I have not personally reviewed all of the documents that were discovered in the.
Okay, so it's very possible that there are more documents.
Mr. Chairman, I simply don't know. I did not perform the internal search. That was not done by.
Okay, well, let's go through it. The deliberative process behind in this letter that arrives in anticipation of your being here, I suspect. Your letter also requests information concerning the deliberative process behind 36B regulations. In addition, you describe a telephone conversation with Treasury staff from March 2013 regarding such information. We disagree with your description, but we've given us no information. I'm going to send you back with a couple of things here today. One of them is this body has every right to the most sensitive information, period. Now, every day we have State Department deliver us classified information related to Benghazi. A keeper sits there. People who are cleared for classified information go through that. If Treasury wants to make sure that information that is known to be such that you do not want it subject to release because of ongoing litigation, tag it. Bring it in here. Let us look at it. If I do not get either in-camera all discovery or hauling it back and forth as appropriate and full disclosure, not only will I issue a subpoena, but I'm going to have to do a lot more. The American people are about to spend more money on this program, perhaps, than any other program launched in its infancy. This is very expensive. And you mentioned Medicaid. Obamacare is effectively simply a Federal pays both sides large Medicaid program. That's really what it's becoming. The Federal taxpayers are going to be on the hook for huge amounts of money. All we're asking for is that you obey the law as written and you provide us information when we believe that you've created a rule that the last panel couldn't find actual language that would allow you to have that interpretation. You've said here today under oath that, in fact, you had a significant number of people, career professionals, who did analysis. You've given this committee no such analysis. I'm sending you back very simply. You were pretty close to a useless witness who came saying, I don't know. And if history is of any indication, the things you said you'll take back for the record, you won't come back with any answers. You didn't send 500 pages. You didn't send 386 responsive pages. You sent almost nothing. The American people, if they're going to spend trillions of dollars, and if they're going to have mandates that are not within the language of the legislation, they deserve that analysis. They deserve it to be non-political. They deserve it to, in fact, have come out of something other than political appointees figuring out how to circumvent a change in the House of Representatives. It's that simple. Thank you for being here. Do you have anything in closing?
No, Mr. Chairman.
Thank you. We're adjourned.